Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. We are going to discuss a case law decided by Honorable High Court of Kerala, wherein default bail, statutory bail was denied to a SFI leader who is involved in 12 crimes and who has whose bail has been cancelled since he violated the conditions of the bail. How this thing happened? Normally, as per section 167 clause 2 of the CRPC, all of you know default bail is defined. So that is to say, if a person is in judicial custody for more than 90 years, for more than 60 days, 90 days and 60 days, and if the charge sheet is not filed within the statutory period, so for offences more than 10 years, 90 days, for offences below 60 days, if the police fails to file the charge sheet, the accused has got a right under CRPC, that is statutory bail or default bail. So this is what we discussed in the doctrine of laches, all of you know well. But here what happened is, even though the charge sheet is not filed, the Honorable High Court of Kerala, single judge, Justice Viju Abraham, he denied bail to the accused person Ashrom P M versus in the case of Ashrom P M versus in the case of Ashrom PS versus State of Kerala. I'm sorry, I have to repeat it. Kerala on 12/7/2022 and cancelled his bail petition filed in CRLMP number 5188 by 2022. So the court clearly held that he is not entitled to bail because he has been arrested for violating the bail conditions. Now we'll go to the facts of the case. Of course, by saying SFI leader, you can easily understand that he belongs to CPM, which is the ruling party in Kerala state. Of course, it doesn't have any political connection. This man is figuring as accused. One case, let us say 1768 by 2020 of Ernakulam PS. Actually, in 2019, an incident happened in Kutan, where this accused, along with a group of persons, trespassed into the rented room of Nissan Nazar of Kottayam, Nissan Nazar of opposite party. Then actually he made an attempt on his life. Actually they were about to kill him. It is an attempt of culpable homicide or attempt to murder, you can say. So different sections, they were booked under different sections. 323, of course, simple. 327, then 455, that is barging into the house during the daytime, or lurking house trespass, HB by day we call it in simple terms. 307, 308, then 506 intimidation, and 427 mischief. They would have spoiled his office or they would have damaged the articles in the house. Cases were booked against him. Right? He was arrested. Of course, he was given bail after 2 months. But the condition given was that he should not involve in any such type of offences. Of course, whether it is possible or not, the court has to decide, because there are occasions where he will be falsely implicated also. Only condition is you should not, that means you should not indulge in such activities hereafter. But what happened? After few days, once again, he was arrested for violating conditions of the bail. He was inside. Right. Previously, he was involved in 40 cases. So as far as this is concerned, he filed a petition for statutory bail as the investigation was not completed by the police and they did not file the charge sheet as per section 167 clause 2 CRPC. But the problem is, no doubt, the police did not file the charge sheet. Friends, the court remarked that the investigating agency is colluding with the accused and therefore they could not complete the investigation. That is the opinion of the judge. That's why I told in the early stage, CPM party, whatever it is, the police failed to file the charge sheet. So definitely, as per the dicta of late V.R. Krishnayar, who is a Keralite, so bail is a right, jail is only exception. But still, the judge is not inclined. There are other cases also. Actually, the advocate on behalf of this Ashrom. He relied on the famous case of Gopinath versus State, that is Madras High Court, which stated that the cancellation of bail or violation of conditions of bail cannot be a ground for using the discretion regarding the bail petition. So, for the present time, the matter beforehand has to be taken into consideration. So, the judge should not think whether he previously violated bail conditions or not. But the complainant, that is Nissan Nazar, he has categorically brought FIRs of his involvement in 40 cases, not one, 40 cases. 12 cases are still pending. So, under these circumstances, the court is not inclined to grant him bail. So, they stated that he has to continue in the custody till the cases are violated, the cases are disposed of, as he violated the conditions of the bail order. So, normally why we are giving bail? Bail is to see that he will move safely in the society. So, if he goes to the society, takes it as a license and once again commit the offence, what is the fun of granting bail? No. So, therefore, the Honorable High Court of Kerala rightly took a strong decision and held that statutory bail cannot be granted on certain occasions. Very good judgment. Please read the judgment. Ashrom P M versus State of Kerala 2022. Right? Thank you very much.